Hi. Okay. So I was giving an introduction. I realized I didn't unmute myself. So, so I would like to introduce you to Robert Cordy. Bob is an attorney at McDermott, Will and Emery in Boston, Massachusetts. Um, for 16 years, Bob had served as an associate justice for the Massachusetts Supreme Judicial Court, and he's worked with judges from all over the world, focusing particularly on judicial independence and ethics. And he is going to talk to us about the interdependent relationship between a independent judiciary and a free press. So we're very, very honored to have him here with us. Thank you, Bob. Welcome back.
Thank you, Gorman. My pleasure as always. Welcome to everyone. I hope to talk for maybe 40 or 45 minutes. I haven't timed this, but would be delighted to take questions and comments for sure as we get to the end of it. I've sort of titled my remarks Necessary Elements to the Creation and Preservation of a Constitutional Democracy, subtitled The Interdependent Relationship Between a Free Press and an Independent Judiciary. I'm going to begin by talking a little bit about history, then moving on through my own experience in these areas internationally, and then back to what I see happening here. The creation of an independent judiciary and the protections afforded to ensure a free press were truly fundamental to the founding of our constitutional democracy nearly 250 years ago. And their preservation remains as critical today as it was then. So let me start at the beginning. Unquestionably, this country's most enduring contribution to human progress is the concept of a democratic government with a written charter that apportions public power, guarantees fundamental rights, and entrusts the protection of those rights to an independent judiciary. Constitutional democracy, so conceived and constructed, has been the foundation of our security and prosperity. Can we pinpoint its creation? I would say yes, about the year 1780. The place, I would say the Commonwealth of Massachusetts. The document, the Massachusetts Constitution of 1780, written by John Adams, in which the concept of a constitutional democracy first gained institutional and practical form. That Constitution began with a Declaration of Rights of the inhabitants of the Commonwealth. It spans 30 separate articles and includes many of the rights we now take for granted, and which were in part added to the United States Constitution by amendment in 1791, the Bill of Rights. Interestingly, and with great insight, John Adams, in this Declaration of Rights, identified two of those he deemed as, quote, essential, unquote, to the security of freedom and the preservation of all other rights, a free press and an independent judiciary. These two cornerstones were to become broadly recognized as fundamental human rights, as well as constitutional, fundamental to human rights, as well as to constitutional democracies, and were incorporated into the Universal Declaration of Rights in 1948, the European Convention for the Protection of Human Rights and Fundamental Freedom in 1950, and the International Covenant on Civil and Political Rights in 1966. Why are these two institutions so vital to a constitutional democracy and the protection of human rights? First, because a well-informed citizenry is necessary in order to participate in the public debates leading to the election of our democratic leaders. And the freedom to speak and write on matters of importance about society, government, and public officials is an inescapable necessity of democracy. The primary vehicle for creating informed citizens is a free and independent press in its many and varied forms. Indeed, the founders firmly believed that if the public press was in some way muzzled or undermined, and a corrupt regime monopolized the public discourse, immune from public challenges, the free state they were creating would be in mortal danger. As one of those founders, our third president, Thomas Jefferson, dramatically proclaimed during the constitutional debates, quote, "If I had to choose between a government without newspapers or newspapers without a government, I should not hesitate a moment to prefer the latter," unquote. Consequently, the freedom of speech and of the press are guaranteed in both the United States Constitution and, of course, the 1780 Massachusetts Declaration of Rights. Second, fundamental to a constitutional democracy is that majority rule in the democracy must be constrained by a written charter of rights that limits the power of government and guarantees the rights of all people, regardless of their majority or minority status in the society. And further, that these rights and protections must be interpreted, applied, and ensured by a judiciary, as John Adams described it, quote, "as free, impartial, and independent as the lot of humanity will admit," unquote, unquote. And surely sufficiently independent of the other branches of government that might be inclined to chip away at those rights and protections. As the former president of the Supreme Court of Israel has so pointedly noted, quote, "A key historical lesson of the Holocaust is that people, through their representatives, can destroy both democracy and human rights, the protection of which cannot be left solely in the hands of the legislature and the executive, which by their nature reflect majority opinion. Consequently, the role of an independent judicial branch in a constitutional democracy arises," unquote. An independent judiciary is a judiciary that is prepared to apply the law equally to all who come before it, regardless of their race or economic status, without fear or favor or outside influences, and is prepared to say no. No to the governor or to the president or the legislature, to acts that are contrary to the rights set forth in that written charter, when the needs of the political moment clash with constitutional guarantees. In other words, we rely on courts to enforce what the Constitution promises and to ensure that we are a government of laws and not of men, as proclaimed in the final article of the Massachusetts Declaration of Rights. The degree to which we can rely on the judiciary to perform this function, however, ultimately depends not on the words of the Constitution, but on the authority the judiciary derives, not through military or political power, but from the support of the people it serves. As Supreme Court Justice Thurgood Marshall wrote in the 1960s, the time of great social upheaval in our country, quote, "The only real source of power we as judges can rely on is the respect of the people," unquote. This respect and support is in turn nourished by an information flow about and an understanding of the role of courts in a constitutional democracy. It also depends, of course, on a track record of the courts acting impartially and fairly over time. These two institutions, the free press and independent judiciary, stand in stark opposition to the interests and inclinations of those with power from time to time, who may regard both the courts and the press as interfering with the exercise of those powers. There is nothing that gets under the skin of government officials quite as deeply as when the freedom of the press becomes a license to criticize and expose their actions, inactions, misadventures, corruption, and incompetence. Indeed, in recent times, the collapse of judicial independence and a fledgling free press in both Russia and Turkey were triggered by news reports of rampant corruption in the Putin and Erdogan regimes there. When the freedom of journalists to speak and write is challenged through prosecution or harassment by government officials determined to silence their voices, independent courts are the principal refuge in a constitutional democracy. Conversely, when the judiciary is under siege by the other branches of government or political partisans for performing its constitutional function in what they view as an inconvenient way, the judiciary is particularly reliant on the press to communicate its plight to the people and on the people to respond to that plight. It is not surprising that once a free press is hobbled or dismantled, the independence of a country's judiciary will surely crumble, as intrusions on its independence and impartiality are buried deep with no discerning public eye. Similarly, stripping the judiciary of its independence by government intimidation or by laws enacted to do so inevitably leads to a shutdown of media organizations and often the arrest, or worse, of journalists critical of the government. This has surely been the case in Turkey, about which I will talk further, and is increasingly the strategy of other democratically elected autocrats, attempting to expand and consolidate their powers in countries such as Hungary, Poland, and others. Many others have recognized and described the phenomenon of an independent judiciary and a free press working in tandem to promote a free society where the rule of law is paramount. It was succinctly put this way by Supreme Court Justice Felix Frankfurter 7 decades ago. Quote, "A free press is not to be preferred to an independent judiciary, nor an independent judiciary to a free press. Both are indispensable to a free society. The freedom of the press in itself presupposes an independent judiciary, through which that freedom may, if necessary, be vindicated. And one of the potent means for assuring judges their independence is a free press," unquote. More recently, United States Supreme Court Justice Stephen Breyer eloquently expressed it this way, quote, "A free press is necessary to narrate to the public what is being done by those in power, to provide them with the information necessary to vote and to make other political decisions in an intelligent way. An independent judicial power is necessary to guarantee the continuing existence of the conditions necessary for democracy, such as a free press, and to ensure that those in power cannot, in practice, strip citizens of the freedoms that, in principle, are guaranteed by a constitution," unquote. Threats to both judicial independence and the free press are hardly hypothetical concerns today in this country. where debates rage over whether the press is the enemy of the people, and critical news is often deemed simply to be fake news. The courts as well are under siege as executive actions, often the product of legislative stalemates or dysfunctions, are challenged again and again in judicial forums, pulling the courts further and further into the political morass. Indeed, the politicization of our judiciary is a matter of paramount concern. If the people perceive the judiciary not as an independent and impartial arbiter and protector of fundamental rights, but as a mere political actor accountable to political benefactors, that presents a potential catastrophic undermining of the institution. Judges must indeed be accountable, but judicial accountability is very different than political accountability. Judicial accountability is faithfulness to the principles of fairness, impartiality, and equal treatment under the law. It knows no partisanship, brokers no compromise, and trades no favors. But let me shift my focus somewhat to recent events on these subjects that I have witnessed in other countries. By way of background, from 1974, when I graduated from law school, up and through 2001, I had the great privilege of practicing American law from many perspectives: public defender, state prosecutor, federal prosecutor, law partner, adjunct faculty member, legal counsel to the governor of Massachusetts, and then as of February 2001, a justice of the Massachusetts Supreme Judicial Court, the oldest appellate court in the Western Hemisphere. What more could one want from the practice of law? Well, I received a call in July of 2001 that was to change the trajectory of my professional life. The call came from a court officer. I was apparently the only justice in the courthouse that summer afternoon working in the library. He told me that there were some Russian judges in the lobby who wanted to know if they could meet with an American judge. Sure, I said, why not? I had no idea what they wanted to talk about or what I might add. Indeed, I knew almost nothing about the post-Soviet legal system in Russia at the time and had little reason to be interested. Well, it turns out the judges were from the recently constituted Constitutional Court of Russia on their way to the US Supreme Court to discuss federalism and how the US Supreme Court was able to get the many states of the United States to respect and comply with its decisions. We began a discussion about what state Supreme Courts do and how they relate to federal courts and the US Supreme Court. But before long, I began asking most of the questions about what was going on in the Russian judicial system. And I became both fascinated and amazed by the reforms that were in process. I have to say the conversation went all afternoon and ended with me being invited to join them in a backyard barbecue in Cambridge, and of course, a complete vodka educational endeavor. That was the beginning of my new life in the rule of law writ large. Within months, the Massachusetts judiciary would join 9 other state judiciaries, in New England mostly, as part of the Russian-American Rule of Law Consortium, partnering with judiciaries in different regions of Russia, funded by USAID, to assist in the implementation of those many reforms. Massachusetts, being the last to join the consortium, was partnered with Tomsk, Siberia. Not Moscow, not St. Petersburg, Tomsk. Tomsk, unfortunately, being the site of the most recent poisoning of Alexei Navalny, a Russian dissident and journalist about which you may have read. The result, in any event, was an 8-year intense relationship that offered dozens of American judges, court officials, prosecutors, and defense counsel opportunities to visit and share experiences with their counterparts in Russia, helping them to implement an adversarial system of justice, explore the principles of judicial independence, advance judicial and legal training and ethics programs, and even helping to implement a jury trial system. In addition to traveling extensively in Russia, we hosted more than a dozen delegations of Siberian judges, prosecutors, and lawyers in Boston. It was an exciting, uplifting, and energizing time. It was a few years later that I began to more fully understand that during the late 1990s and the early 2000s, Russia was indeed in need of Western capital, and Western capital was not about to come unless there was an independent and credible judiciary available to ensure the protection of their investments. And consequently, the leadership of Russia, through constitutional reform and statutory initiatives, appeared earnestly to be striving to create a rule of law environment centered around an independent judiciary. This environment paralleled the rise of an independent media in Russia as well. The reforms were both sweeping in scope and rapidly moving forward. But I remember asking the chief judge of the commercial court of Tomsk, Siberia, about 3 years into our collaboration, how she felt about the future of those reforms, and especially about the emerging role of an independent judiciary as their linchpin. Her answer was prophetic. We are on the razor's edge. We will not know whether these reforms will truly last until the government pushes back. And that it did. Oil hit $100 a barrel, and beginning in 2008 and 2009, the newly independent press began reporting on allegations of massive theft and corruption at the highest levels of government. Putin concluded Russia did not need Western capital anymore, or independent judges, or for that matter, a bothersome free press any longer. And just like that, the enterprise of reform collapsed, and our collaborations, one of many, were shut down. American judges were no longer welcomed in Russia, and Russian judges were barred from traveling out of the country. And of course, journalism got very dangerous. Russia quickly delicensed much of the independent TV media, and only the government network became available. In any event, in July of 2010, the year after we had been thrown out of Russia, I got another call from a court officer. There are some Turkish judges here who would like to speak to an American judge. Oh my, here we go again. As it turned out, the Turkish judiciary had just begun sending 10 judges and their families to Boston each year for a 10-month period to learn English and something about the American judicial system. And I was meeting with the first of those delegations. They had completed their stay and were preparing to return to Turkey, but they hadn't had any interaction with American judges during their stay and wanted to discuss the possibility of creating such interactions when the next delegation arrived in the fall. Well, it didn't take long to develop a partnership with each new group. As a result of these partnerships, in both 2012 and 2013, I was invited by the Justice Academy of Turkey to bring delegations of state and federal American judges to Ankara to share our experience on a wide range of important topics, including judicial ethics and judicial independence. Indeed, our week-long visit in 2013, ironically, was dedicated entirely to free speech and free press issues under the American and Turkish constitutions, a topic chosen not by us, but by the Justice Academy. Of course, Turkey at the time was working eagerly towards the goal of becoming a member of the European Union. And among other things, it needed to demonstrate that it had a modern, independent judiciary and a free press to qualify. The Justice Academy had been established to train future judges and prosecutors to meet those needs. The leadership team at the Academy included some of the most capable, dedicated judges and instructors I have ever met at any institution. Well, all this began to crumble at the end of 2013, when then Prime Minister Erdogan and his family were publicly named in the electronic media in connection with a multi-million-dollar corruption investigation. Erdogan quickly ordered access to Twitter blocked, threatening to, quote, rip out its roots, unquote. He then put severe restrictions on YouTube. Sound familiar? TikTok wasn't yet available. Both actions were declared a violation of the freedom of expression provisions of the Turkish constitution by the Constitutional Court of Turkey. That was enough. An insidious campaign to cripple the judiciary and destroy what was left of the free press quickly commenced. The executive branch sought and obtained changes that essentially enabled Erdogan and his allies to take over the administration of the judicial branch. The leadership of the Justice Academy was dismantled in 2014, and judges were suddenly reassigned, and fear began to spread. Literally thousands of judges who were not viewed as being fully aligned with the government were being abruptly reassigned again and again to distant regions of Turkey, disrupting their families and their professional lives. All of this in violation of Turkish law, by the way. But who is going to enforce such a law? Not happening. Then in February of 2016, the Constitutional Court of Turkey again defied Erdogan, freeing two prominent journalists from a detention center, pending their trial on the crime of reporting on Turkish intelligence agents delivering arms to Islamist rebels in Syria, which the court opined was probably not a crime at all. Erdogan angrily declared, "I don't obey or accept this decision," and the unraveling of the judicial independence took a turn for the worse. In July of 2016, you may recall, there was an alleged coup against Erdogan's rule, which was quickly suppressed. But within days of that alleged coup, more than 3,500 judges and prosecutors deemed by Erdogan as potentially not aligned with the government were imprisoned and their assets were seized. Almost all remain in prison today, including, not surprisingly, several justices of the Constitutional Court and virtually every judge who had any substantial contact with American judges. A few got out on rafts for Greece and eventually sought asylum in Germany or the US, but only a few. Not surprisingly, no judge in Turkey today would even consider ruling against the government. Journalists who dared criticize the government or its leader suffered a similar fate. Insulting the president of Turkey became a crime for which hundreds of journalists, cartoonists, and opposition leaders have been prosecuted. Indeed, those criticizing the government are often deemed as to be aiders and abettors of terrorism and prosecuted as such. I note that just last week, Erdogan ordered a criminal investigation into a Greek newspaper and several of its journalists for publishing an insulting headline about him. Not surprisingly, up until this year, Turkish jails held the title of housing more journalists more journalists than any other country in the world. And there are no longer any independent judges prepared to protect whatever rights they might have had under the Turkish constitution. China just edged Turkey out of the title this year because in Turkey now, virtually all independent media organizations have been forced out of business by the government. So there are far fewer journalists to imprison. Problem solved. So in a new initiative, the Turkish government has just begun arresting and prosecuting lawyers who, by vigorously representing the government's critics and imprisoned judges, are themselves accused of aiding and abetting terrorism. It is truly the rule of law turned upside down. And trust me, it can happen elsewhere. One need only look to Poland, for example, where the ruling party and its democratically elected autocratic leader have pursued several strategies to cripple and then take control of the country's judiciary, including enacting a law dramatically lowering the mandatory retirement ages for judges, which was to apply to all judges then serving. If implemented, hundreds of the country's most experienced judges would have been removed, opening the opportunity for the ruling party to fill vacancies with its supporters. These laws were recently struck down by the European Court of Justice, but other crippling initiatives remain underway. So we have two tragic examples of how fragile these fledgling constitutional democracies can be, Turkey and Russia. And in their demise, I have viscerally witnessed how precious and necessary two institutions were to successful constitutional democracies, a free press and an independent judiciary. I have now worked with judges and journalists from more than 30 countries, and it has become perfectly clear to me that the path to autocracy requires the neutering of these institutions. And down that path go an alarming number of countries on the razor's edge of autocracy. So who or what is to protect the independence of the judiciary and the freedom of the press? Words in a constitution, after all, are just words. And the strength of these two institutions in large measure depends on public trust and the capacity and willingness of other institutions in civil society, business, academic, charitable, and legal organizations, for example, to rise to their defense. This is especially the case when the legislative branch of government seems incapacitated by its own dysfunction. Most importantly, the preservation of liberty, in the words of Justice Louis Brandeis, requires courage. Courage of judges to be independent, accountable only to the law, and the courage of journalists to search for and inform the public about the government, its officials, and their actions in the face of hostility and danger. And when the gauntlet is thrown down and the elected leader begins to move on the judiciary or the free press, the courage of other institutions to stand up and stand with them. Fortunately, this country has a strong legal community whose members may regularly battle each other on the legal playing field, but who deeply respect the rules of play and the need to ensure the viability of the stadium of liberty and law in which they do play. We also have very strong academic, civic, and business organizations, which are capable of rising to the challenges of autocratic creep and the excesses of populism. The only thing none of us or them can be is complacent in the face of such challenges. Indeed, the institutions that may block an aspiring autocrat depend on one another for mutual support. After all, if nothing else, they may be the next victims of vilification. It is not surprising, although shocking, that Erdogan also dismissed tens of thousands of academics and educators in his post-coup purge of organizations that might resist his democratic autocracy. He also directed the rewriting of the textbooks to be used in public schools there. So how do judges, lawyers, educators, and journalists ensure that the public is well informed about the courts and the pivotal role that an independent judiciary plays in a constitutional democracy? How do we build that foundation of public respect, which enables judges to do their jobs without fear or favor? Supreme Court Justice Stephen Breyer, again, got it exactly right when he said that, quote, judicial independence is ultimately a question of helping the people understand. Back to the Massachusetts Constitution of 1780. Not only did John Adams deem a free press and an independent judiciary essential to the security of freedom and the preservation of rights, in Chapter 5 of that Constitution, he wrote that, quote, wisdom and knowledge diffused generally among the people is also necessary for the preservation of their rights and liberties, and that education should accordingly be cherished, quote unquote, by future governments. You are the diffusers, and that's why you share this mission. The need for public understanding of the role of our courts and our free press puts an obligation on all of us. Judges must be more communicative about their role, and journalists must probe beyond the sensational trials to understand and help others to understand the central role of judicial independence in our constitutional democracy. And those who teach and guide the future generation of citizens need to prepare their students for the challenges to both that lie ahead. And those challenges have gotten very complicated in the age of the internet. How do we get news we can rely on? How do we separate facts from opinions? And why are these things important? Indeed, enlightened decision-making by an informed citizenry is the basic ideal upon which an open society is premised. And our society depends heavily on all of us for that enlightenment. In Massachusetts, the judiciary and the media have worked diligently to ensure a better understanding of their respective roles and responsibilities. In 1996, the Massachusetts Supreme Court established a Judiciary Media Committee made up of judges, court personnel, representatives of print, electronic, and social media, and attorneys practicing and specializing in media and free press issues. I had the good fortune to be the judiciary co-chair of that committee for many years. Its purpose has been to foster positive working relationships and build trust and understanding between the media and the judiciary. It has served as a forum for discussion about media access and coverage of court proceedings and records. It has also served as an advisory body to the Massachusetts Supreme Court in its efforts to broaden and modernize the court's rules regarding new forms of electronic access to court proceedings and records. And it has served as an organizing force for educational programs, both for judges and for journalists, about their respective roles and responsibilities, and about the rules of ethics and procedures which govern their conduct. I've had the good fortune to take the work of this committee and talk about it in many other countries. They're quite intrigued. You mean judges and journalists actually talk together, reason together, have discussions? I remember in Ukraine convening a panel of judges and journalists, and they were stunned that they could actually talk to each other about important issues of coverage, how the courts work, the needs of journalists. I've done the same in Macedonia, in Uzbekistan, in Turkey. In any event, it was a very important committee and a very important precedent. The goal, however, was not to convince the media to stop writing critical articles about court cases or judicial behavior, but rather to create a civil dialogue from which better informed coverage of court proceedings might emerge. The work of this committee has significantly improved the environment in which reporting about what goes on in our courts occurs. Justice Oliver Wendell Holmes once observed in 1894 and I have got this interpreted and translated into about 14 different languages. This was when he was on the Massachusetts Supreme Court before he was appointed to the US Supreme Court. Quote, "It is desirable that judicial proceedings should take place under the public eye, because it is one of the highest moments that those who administer justice shall always act under the sense of public responsibility, and that every citizen should be able to satisfy himself with his own eyes as to the mode in which that public duty is performed," unquote. Well, the press is that public eye, and the transparency of judicial proceedings and actions is critical to judicial accountability. Judicial transparency has been promoted and protected by a vigilant press, acting as the eyes of the public, reporting on the diligence of judges, the substance of their decisions, their treatment of persons appearing before them, and on the inefficiencies and efficiencies of the judicial process. A well-informed press has consistently played a vital role in prompting significant improvements in judicial conduct and operations, as well as enhancing public understanding and respect for what courts do. The press is not the enemy of the people, and the judiciary not just an ornament to be hung up or taken down at the whim of a disgruntled leader. The disparagement and diminishment of these two institutions is a key and vital early chapter in the autocrat's playbook, and no one should think otherwise. So what is my message this afternoon? Well, while there may be many reasons for and causes of the unsettling current state of affairs in our country and quite frankly around the world, where the seeds of mistrust regarding the judiciary and the press are now regularly sown, complacency in such times is unacceptable. Even though our institutions are stronger here than in similar institutions in Russia, Turkey, Poland, and elsewhere, it is our collective obligation to affirmatively engage in civil debate about their challenges, to protect them when necessary, and to ensure the continuation of our constitutional democracy, even through its darkest hours. There really is no alternative. Thank you for your attention. Let me see, how fast did I do? Whoa. All right. Okay. 14, 15 minutes. I saw some questions coming. I'm delighted.
Yeah. So yeah, we'll go through the chat and take a look at the questions that people are asking. But I'm going to start with a question just in terms of my observations, just in, of course, obviously in the recent month. Justice Ginsburg's passing, and the move to replace Justice Ginsburg's seat, not necessarily about the process, that the constitutional process, but it's really more about the politicization of the courts, particularly at the Supreme Court. When I hear, the senators on both sides, both Democrat and Republican, it seems like the vetting process is really focused more on the partisan views of a nominee versus really looking at the law, what the law suggests, so I didn't know, like, in terms of what your thoughts were or your initial impressions when you hear, Republicans saying, well, we want this person to be more conservative, and then the Democrats are saying, well, that they're too conservative, should be liberal. I mean, how, and maybe that's always been the case throughout our history, is having that partisan view. But what do you believe could be the safeguards or measures that could be put in place to make sure that politics is, I don't know what's the word, but but how can we ensure that that politics doesn't play a major role in the nomination process, or is there?
Well, a couple of things. I mean, largely, it depends on the quality of the candidates and their commitment to the judicial mission. I hate the politicization of the nomination and appointment process. It's horrible. It terrifies me. Ultimately, the judges who are appointed to that court in particular have to do what judges are required to do, which is to set aside their personal policy views and to focus on the law. And this gets complicated, and this is part of my great concern about the Supreme Court over the last 30 or 40 years, not just recently, has been pulled more and more and more into the public policy arena. We have a separation of powers, which means the judicial branch should never essentially be making policy. And their rulings should be respected by the executive branch. And this sort of separation of power is somewhat at the root of all this. So courts need to be cautious and conservative in the sense that we are not elected legislators. We are not here to set public policy, good policy, better policy. We're here to interpret and apply the law as best we can. And sometimes that requires, I don't want to say setting policy, but ensuring that the schemes, the legislative schemes at issue are consistent with basic constitutional principles, which may occasionally sound like public policy making, but it shouldn't be.
This is like one of the great things about virtual conference. But
oh boy.
All right. Let's try this again. So yeah, so continue on what you were saying about your concerns with that politicization of that court.
At the end of the day, it's up to judges on that court to ensure that it does not become simply another political body. And history shows. I mean, Chief Justice Earl Warren was appointed by a Republican because there was a sense he would be conservative. He was the most progressive Chief Justice almost ever on the U.S. Supreme Court. Justice Souter, again, nominated and appointed by a Republican, became a very moderate and important voice on the court for decades. So, and I think Chief Justice Roberts is trying very hard to fit into that mold as well, and trying to depoliticize things to the extent he can. But when the court gets pulled into these essentially public policy questions that ought to be resolved by the other two branches, this is what happens.
Yeah. So we had some questions.
Yes.
This was from Tom. He wrote, if Julian Assange was extradited to the U.S. to face journalism espionage, will it sound the death knell of freedom of the press?
I don't think so. There are levels and rules that apply to all of us, no matter what. But I won't go down too far down that road. But I will say, and I think one of the questions related to how does one get reliable news? What are the sources of news that can be trusted, or should be consulted? I get this question all the time from very mature people saying, where do you get your news? What do you trust? Yeah. And I think there are two pieces to that. One, you've got to sort of identify some reliable sources of professional news gathering. AP, I read the Globe, the Herald, the Wall Street Journal, the State House News. I watch various, Fox, CNN, ABC, NBC, to sort of get the factual framework for what's going on. The harder problem is separating, news from opinion. And I remember in 8th grade, my social studies teacher teaching us that we needed to separate opinion from facts, and we need to have different sources of facts and be able to compare them. And this has become very problematic. I mean, almost everything in the newspapers these days is affected by the opinions of the papers. And so it's very important to teach students, I think, how to deal with this.
Yeah.
Social media is not a place to get, there are a few websites that are good, but social media is not the source of professional news gathering.
All right. Yeah, speaking about, let's see, this other question, this is from Craig. We count on the press to tell us the truth, however flawed it is based on our own biases. But when the press purposely violates long-standing journalistic standards to advance their own purposes, rather than their fiduciary duty to inform the populace, how can the judiciary hope to be objective themselves when faced with a lack of consensus of the truth?
Well, the judiciary or the judicial system actually, apart from reporting or press purposes, the judicial system has actually a pretty darn good way at getting at truth. That is what trials are all about. That is what that's at the heart of the system, getting at the truth as opposed to what people may say about what it is that's true. I'm not sure the press has quite a disciplined system to get at the truth, but they ought to be called upon it. And that's why you need to have different sources of information so you can better judge what's true or the closest thing you can get to truth versus what other people may want you to think about or think of.
Yeah. And then another question from Tom: Can one state our press is owned by autocrats and basically publish propaganda from the government?
Well, that happens all the time.
Yeah.
I mean, certainly in many countries, Russia's a great example. I mean, the only news you get is what the government directs the news to report. It is a government vehicle for its own purposes. And it's that way in many, many countries, unfortunately.
Yeah. Yeah. So, I mean, we say that our democracy is fragile, which is, I guess it's always been fragile, right? And thinking about the Constitution and particularly, like the First Amendment, are there other ways or measures to just make sure, like, what other ways can we think of in terms of preserving and safeguarding, our freedoms, the press? I mean, beyond, you got the First Amendment, and that pretty much secures, freedom of the press, right? But
and lots of different viewpoints.
Yeah.
And so that's why I think you have to have different sources.
Yeah.
To help you sort of understand what may be closest to the fact situation. If you rely on one source, you will sometimes be burned, where that source has its own reasons for reporting something in a specific way. Yeah. So you sort of have to rely on the press to go after each other a little bit. Obviously, if a question gets to court, there's a whole process. It's not a question of, who has the most gets on or the most viewers on their website. It's a very different process of truth finding.
Yeah. Yeah. And so I guess, one of the responsibilities, I guess, the civic responsibilities of teachers is to really, teach students to corroborate their sources, right?
Absolutely.
And be critical in anything that you read, right?
Unquestionably.
Yeah. So, and then maybe that's something that, maybe needs to be relayed to just for the general public as well, you know.
That's true. But the best social studies teacher I ever had was the gentleman who made this very point.
Yeah.
You have to be able to take different sources of information and separate out opinion from fact. And we did that 3 days a week by reading the New York Times and the
Right.
daily news and sort of discussing it.
Yeah.
It was a really important lesson of my life.
Wow. Yeah. All right. Well, thank you very much, and apologies for all the technical difficulties. But I recorded this session and as well as the other session, so I can always, you know, do the magic of video editing and being able to put it all in one piece to show that there was nothing ever happened. You know,
nothing. My pleasure. My pleasure.
Thank you. Thank you
Take
again
care
very
now.
much.
Bye.
All right. Thank you.